opinion seemed to go that direction. That's not exactly a Zen state, but
No, tell me one more time on that. 'Cause
I have joined opinions from the court where I would have wished the result were different. So you have to go away from your personal preferences. If the development of the law, if the opinion shows you that that's where the law needs to go.
Are you no longer a dissenter then? Can't you just dissent?
Oh, no, you don't dissent just because you don't like the opinion. You dissent because you think the law that was articulated there was wrong.
Interesting.
I have dissented on occasions, and of course every dissent cites the law, has a completely different view. You might read the majority and think that makes sense, and then you read the dissent and you say, oh. So I have joined opinions where I didn't like the consequences, but I felt that the law, after all, we don't all agree with all the law, but that the law required that. And I have written dissents where I felt that the majority misconstrued the law.
That kind of brings up the importance of taking a big look at law again, of cross-examination, where someone has made the point where if you listen to just in the prosecutor's speech in the beginning, you might have to draw a complete picture of that.
Absolutely.
And then suddenly the defendant, the lawyers, and then you have an entirely different perspective.
Absolutely.
And one has to have a fair cross-examination of every issue, right? And that's
Absolutely.
partly what does that go on at the Supreme Court level too?
Well, yes.
Where sometimes you might feel like you might be getting railroaded as it goes around the circle, and you have to stand up against it.
Well, you're supposed to think for yourself, but
Right.
you're speaking about whether to grant or deny, but also once a case is granted, it's assigned to a particular justice. But I want to step back. We get briefs from the parties, which is comparable to your direct examination and cross-examination. The person who is appealing or petitioning writes us a brief. If you read that brief and it's a decent attorney, it's very persuasive. Then you pick up the respondent's brief. You think, oh, it's just like you were describing. And the petitioner, the person who is aggrieved, gets the last word in their brief. So you have the opposing points of view. And then, of course, we have oral argument where you get to question or listen to the attorneys argue their cases.
Let's step back into your own personal history of the cases that you looked at over your term, and tell me, you told me just a few minutes before we started that there was one that was particularly exciting or dramatic. Do you remember that, what you were saying?
Yes, I do. I do. That was a case, I was new on the California Supreme Court, and it was in the era when the three strikes law had first been passed. The three strikes law, your viewers might remember, was in the wake of the horrendous and